Welcome to freeinhabitant.info, a site designed to give sound foundational evidence of the limitations of law. My name is Paul John Hansen. I am the author of this presentation. I live in Omaha, Nebraska. And I have been a student of law for over 15 years, and have been in court more than 200 times for a wide range of my own personal legal matters, consisting of both civil and criminal cases. I have assembled this presentation, titled as Freeinhabitant One A, in hopes that it will be presented to many for the furtherance of understanding of the difference from a free inhabitant and a United States citizen, as the terms are used in Article 4 of the Articles of Confederation of 1777. The primary topic that will be covered by this presentation discloses the difference between land that is owned by the United States of America and governed by the United States written law and known as the United States Code, and conversely land that is not owned by the United States of America and is not governed by the said United States written code. Other topics briefly discussed in this presentation are: 1. Licensed attorneys only have permission to practice law on land owned by the USA. 2. The legal difference between the United States of America and the United States. 3. Why your land you live on, and the property associated with that location, is most likely not legally included in their state property tax statutes, and how you can prove it. The presentation is 1 hour long, and has 75 slides. The cost is only $5, and delivered generally by email the same day. A one-page clip from the visual/audio presentation is slide 55. You can read the slide on your leisure. What I wish to notice everyone on is the fact that jurisdiction of applying written law at a specific place can never be affected by the plaintiff, defendant, or any court. So even if you royally mess up in court, or even if you tell the judge that he does have permission by legislative authority, or even said the land was USA owned, this does not change the fact of who owned that land. At any time that ownership alleged fact can be challenged, and if said proprietary relationship is not provable, the case and all orders associated are to be vacated, void, as though they never existed. Yes, if you paid a parking or speeding fine, or a property tax assessment, or any judgment against you by a civil suit, all, if not tried in the right court holding the said general jurisdiction, are all void judgments, for in America the U.S. court must have factual authority to make any ruling of any act at any given location. So what is being presented here is that the 1787 Constitution only gives U.S. courts authority to administer its written laws only upon government-owned land or associated with fully disclosed agreements, contracts, with the United States. So any acts on land that is not certifiably provable at the Office of the Bureau of Land Management of that district, not proven to be owned by the USA, is not subject to any U.S. court or any U.S. written law, and remains 100% independent to be adjudicated in a free inhabitant's court by an English common law proceeding. Or better said, the Christian English common law. So pay no attention to the county assessor's records as documenting it to sound like the land is owned by the USA, for such records are only legally presumptive and is not necessarily the facts. Make no, I repeat, no assumptions, period. Just because it sounds like it is owned by some government entity does not make it factually true. As you have seen, this is the chains of our ever-expanding government. It is called limited jurisdiction, and limits the vast amount of our daily lives in the protection of where you chose to live, in the hands of your neighborhood jury. This is what all abusive governments hate, because that makes them subject to that jury when they do acts in that neighborhood. Now would that not change everything? Would not the Branch Davidian complex in Waco, Texas, been different, or Ruby Ridge, or the 9/11 investigation, to just name a few of the hundreds? What will U.S. courts do to keep this from proceeding? Only time will tell, and each case and each judge will be different. But I recommend that you always give a lesser damaging reason for them to vacate the judgment alongside this argument, so the judge can dismiss without being the judge. That set the U.S. system back 200 years. There are exceptions. If one shoots an arrow into the U.S. District of Columbia, for example, they have right to seek prosecution or remedy, but it must incorporate legal process of extradition. Order the $5 presentation by visiting freeinhabitant.info. Or for more information visit pauljjhansen.com. Every person that has received this presentation has been very pleased with eye-opening information and was eager to share it with their friends and family.